All right, if you're gearing up for the Queensland bar, you know that evidence is absolutely everything. But what happens when your most important witness can't physically be in the courtroom? Well, this explainer is going to be your guide to mastering a really critical tool, taking evidence out of court, specifically under UCPR Rules 396 to 409. Let's make sure you're ready for the exam and, for actual practice.
Okay, before we jump into all the exceptions, we have to start with the fundamental principle. The gold standard, the big idea from Rule 390, is that evidence at a trial should be given live, orally, in person, in the court. Every single rule we're about to talk about is a departure from that core idea, so you've got to keep that in the back of your mind.
So here's our game plan. We're going to start with how you actually get the court order, and then we'll walk through the whole examination process itself. We'll even cover what to do with those tricky, uncooperative witnesses, how to take evidence from overseas, and then the final crucial step, getting it all admitted at trial. It's the whole journey from A to Z. Let's get into it.
All right, your first and honestly your most important tool in this whole playbook is Rule 396. This is the rule that gives the court the power to order an examination to get evidence before the trial even starts. You can think of it as the key that unlocks this entire process.
So what exactly is an examination order? Well, to put it simply, it's the court's official stamp of approval to depose a witness. That is, to question them under oath, but outside of the trial itself. And, like Rule 396 says, this can happen with a court-appointed examiner anywhere, from Brisbane all the way to Berlin. Now, as counsel, you're the one who has to argue for this. The court's discretion under Rule 396 is pretty broad, but it's not a free-for-all. You have to convince the judge that it's in the interests of justice. Is this evidence really that important? Is it material to your case? The court's going to do a balancing act, weighing things like a witness's poor health against the other side's right to cross-examine them in person. Cost is a big factor too, and so is how important it is for the judge to actually see the witness's face and their demeanor.
It's really crucial to get how the court's thinking on this has changed over time. Back in the day, the test was super strict. You practically had to prove a witness was on another continent or physically couldn't get out of bed. But the modern approach under Rule 396 is way more pragmatic. Today, it's all about justice and efficiency. You can actually win an order just to save precious court time, a move that would have been almost unthinkable in the past.
Okay, so the court's granted your Rule 396 order. Fantastic. Now you're in the deep end of the procedural mechanics. That's Rules 397 all the way to 404. These are the nuts and bolts you absolutely have to know for the exam. Let's kick it off with Rule 397.
Rule 397 is pretty simple, but it's so important. As the party who got the order, the onus is on you. It's your job to get the examiner all the necessary documents, the pleadings, any affidavits, basically anything they need to get up to speed on the case and understand what questions are going to be relevant.
Now pay very close attention to the timelines in Rule 398. This is prime exam material. First, the examiner picks the time and place. Then they give you at least 7 days notice. Then you have to give everyone else, the witness, the other parties, at least 3 business days notice. And here's the kicker. Under Rule 398, subsection 5, if the witness isn't actually a party in the case, you absolutely must serve them with a subpoena. Don't forget that part. So, Rule 399 basically lays out the rules of the road for the examination itself, and it's designed to mirror what happens in court. Everyone can be there. The evidence is taken in that familiar sequence: examination in chief, cross-examination, and then re-examination. The examiner isn't just a potted plant either. They can jump in with their own questions to clear things up, and they can call for an adjournment if things get complicated.
Okay, what if, in the middle of all this, you realize you need to examine someone who wasn't on the original order? Well, Rule 400 has you covered. If your examiner is a judge or a magistrate, they can just grant an application to add that person. But if the examiner is not a judicial officer, you're going to need the written consent of all the other parties in the case.
Objections are pretty much inevitable, right? Rule 401 gives you the formal process for dealing with them. The objection gets noted down, the question gets put on ice for a moment, and the examination carries on. Later, a party can go to the court to get a formal ruling. This is just so practical, because it stops one single disputed question from grinding the whole process to a halt.
Rule 402 is all about the integrity and the authentication of the evidence. It makes sure everything is captured accurately so it can be used in court later. The deposition has to be properly recorded, written out in a Q&A format, and then read and signed by the witness. And if they refuse to sign, no problem. The examiner can sign it instead, just making a note of the refusal. The whole thing is wrapped up with the examiner's final authentication. That's the official seal of approval.
And finally, two little rules, 403 and 404, to wrap things up. Under Rule 403, the examiner files that final authenticated deposition with the court registrar. Then under Rule 404, the examiner can also file a special report to the court, maybe to comment on how the examination went, or, to mention if a witness was a no-show.
But what happens when your witness just refuses to play ball? They don't show up or they sit there and refuse to answer a question. Now, if your examiner isn't a judge, they don't have any inherent power to force anyone to do anything. That's where Rule 405 comes in. This is your enforcement mechanism. This is the muscle.
You can bring out the big guns of Rule 405 in 4 specific situations. If your witness doesn't show up, if they refuse to take the oath, if they refuse to answer a perfectly lawful question, or if they won't hand over a document you've asked for. Boom, that's your trigger to start the enforcement process.
The process under Rule 405 is a really clear step-by-step path to get what you need. First, you get a certificate from the examiner that just spells out the refusal. Then you file that certificate with the court. The court can then issue a binding order forcing the witness to comply and, this is the best part, ordering them to pay for all the costs their little refusal has caused. Now let's talk about witnesses who are overseas. A simple examination order under Rule 396 might not cut it, especially if they're not cooperative. I mean, a Queensland court order doesn't have any real teeth in another country. And this is where you need a letter of request under Rules 408 and 409.
So this brings you to a really key strategic choice. For a witness who's happy to help, a Rule 396 order is great because it gives you direct control. But for an uncooperative witness who's abroad, you need a Rule 408 letter of request. This uses international treaties and asks a foreign court to use its power to compel the witness. So to put it simply, Rule 396 gives you control, but Rule 408 gives you enforcement power in another country.
To get a letter of request going under Rule 408, you have to file a very specific bundle of documents. You'll need the letter of request on the right form, any written questions you have, certified translations if you need them, and copies of the whole lot. And please, don't forget the undertaking required by Rule 409. This is a personal promise from your client, or from you as their solicitor, to pay for all the expenses that the foreign court racks up.
Okay, you have done all the hard work. You got your order, you conducted the examination, and you've got this perfectly authenticated deposition. But you are not done yet. The final step is making sure that deposition is actually admissible at the trial.
It all comes down to Rule 407. This is the final gateway. For your deposition to be admissible as evidence, it has to meet one of 2 conditions under Rule 407. Either it was made under a valid examination order or some other act of Parliament specifically allows it. This is the last checkpoint that makes sure only properly sanctioned evidence actually makes it into the trial.
So let's do a super quick recap of the essential rules for your exam. Rule 396, that's your power to get the order in the first place. Rule 397 to 404, that's your procedural playbook. Rule 405, that's your enforcement tool. Rule 408 is for going international with a letter of request, and Rule 409, make sure the bills get paid. And finally, Rule 407, the ultimate test to get it all into evidence.
And that leaves you with the big strategic question you're going to face in practice, and probably the kind of scenario you'll see on an exam. See, it's not just about memorizing the rules. It's about knowing when to use each of these powerful tools to best advance your client's interests and lock in that absolutely vital piece of evidence.